Right, good morning, everybody. We've got probably 30 people so far, and we've got about, I think, 65 registrants. So I'll give you guys just a few more seconds for a few more to join. In the meantime, I'm Christy McGregor. I'm a partner at Ashcroft Mitchell McGregor, a newly established firm that just opened on the 1st of August. I'm accompanied by Shush, who's a partner in our Auckland office and specialises in immigration, and Tash Jurisic, who is from Pillar Consulting, which is an HR consultancy that we work closely with. Right, we've got a few more people. That's fantastic. I just wanted to say at the outset, thank you everyone so much for coming. This means a lot to us, being a newly established business. We're super excited to have you and excited to be showcasing Pillar as well, who we work quite closely with. So we are the North Island part of what was Copeland Ashcroft. Made up of 4 partners, and we are providing services from Northland, Auckland, Tauranga, and the Hawke's Bay, and throughout New Zealand. We do all aspects of workplace law. That includes employment law, health and safety, and immigration, and everything in between. Tash from Pillar is a managing consultant, and she works across all industries in providing health and safety consultancy advice, right from operations right to the boardroom. So to give you an overview, I think I've got the biggest chunk of this presentation, and that's because there's so much change. So what I'm going to talk to you about is some of the legislation that's been passed, and then also legislation that's in bill form, which is currently before Parliament, and changes that have already been implemented and which we're still just getting our heads around. So there's actually quite a lot to talk about here. I've also got some case law to talk about, but I'm going to try to limit that as much as possible because we've only got an hour. We're very happy. I'm very happy to accept questions along the way, so don't be shy. If you've got a question, I'm more than happy to talk about it. There's a lot. So you might find I rush over some parts just for the interest of time. But if any of you do want to engage with me or have any questions afterwards, certainly feel free to reach out. I'd be more than happy to speak to you and answer your questions. So these are the things we're going to be talking about. The Employment Relations Amendment Bill, which has got a whole lot of changes in it, and which is currently going through Parliament and the process. We've got the Parental Leave and Employment Protection Act changes. We've got a change in regards to employee remuneration disclosure. And then we're going to talk a little bit about the health and safety reforms, the crime theft by employer legislation that's been passed. And then Shush is going to talk about changes to the immigration framework. And then Tash is going to talk about changes to workplace drug and alcohol framework and a change to their standards. So there's a lot of content here, but we will be distributing the recording if you would like it. And certainly you're more than welcome to our slides. So moving to the Employment Relations Amendment Bill, the first key change, and it's quite an important one for many of our clients, is the contractor gateway test. So government is trying to legislate to make things easier for business and to have a strict test, which if you can tick the boxes, your person should be a contractor and not an employee, and you don't have the worry of deemed employee claims. I mean, that's a huge issue. Obviously, most people are aware of the Uber cases. Are they not? The employment court didn't agree. And so there's a need for more certainty. And certainly my understanding is Uber has been working really hard behind the scenes trying to get Parliament to implement some changes. Changes to personal grievances, which comes with the Employment Relations Amendment Bill. I could tell you my personal view on it. It's a bit scary in my view. And I can talk to you about why I feel like that. The topic of this presentation is time for change with a question mark. And my question is, are these all changes that we need? And is there the potential that these changes get implemented and then subsequently revoked if we have a change in government? So it's interesting times. In my view, these changes are probably the most broad sweeping that we've seen with changes in government. There's normally some tweaks. We might have changes to the 30-day rule and trial periods, but this is quite a lot more extensive. The high income threshold, everyone earning 180 plus should be concerned about this and thinking about it, and the end of the 30-day rule. So if you've got a collective workforce, it's definitely something to be thinking about. So contractor gateway, we've talked about this before. It will help determine whether someone is potentially a deemed employee or a contractor. It's putting the emphasis on what you say should be what the relationship is. And I think there's a degree of fairness in that. If you call someone a contractor and they're invoicing as a contractor and they've got the freedoms of a contractor, should they not just be a contractor and not have the worry around deemed employee claims? So we've got many industries that are very much dependent on contractors or have a lot of contractor arrangements. Obviously, we've seen in the building and construction area that in the harder times that we've seen, many builders in that space are moving people to contractors, whether that's a fair move or a sign of the times is a question. And we've had a lot of cases challenging that, and the existing test is what is the real nature of the relationship. So it allows the courts to actually get into the minutiae and say, no, we don't agree, despite the fact that you've written this as a contractor arrangement, it isn't. So here is the test, and this is definitely something to hold on to. It's quite a helpful little table. So if we've got somebody that's challenging employment status, this is the question. These are the questions that need to be asked. So number one, is there a written agreement that specifies the person as a contractor? So you'll always pass that test if you've got an arrangement that's called a contract for services with a contractor. Is the worker not restricted from working for others? And I think this is really fair. So you can't have it both ways. If you want someone tied to your business and being essential to it, they're an employee. And if they have freedom to actually be in business for themselves and work for others and not restricted, then yes, they qualify. Is the worker not required to be available to work certain times or days or for a minimum period? Or alternatively, if they don't have the freedom to determine when they work, because sometimes they just can't, is the worker able to subcontract? So I would say most contract for services that we prepare will already have the ability to subcontract, but we would suggest that if you are going to do that, that you include provisions allowing the principal to vet the contractor, because you don't just want Joe from down the road turning up and able to perform the services. And then the business does not terminate the agreement for the contractor not accepting an additional task. So if you say to your contractor, these are the services as defined, but we also need you to do this that's outside of it, and they say, no, I'm not going to do that, you can't terminate the agreement for their refusal. So that is just restricted to additional tasks, not the ones specified. If you can tick those boxes, you get past and you are determined to be a contractor, and it should go no further. But if you can't hit those boxes, then you'll go into the standard test of real nature of relationship under Section 6 of the Act. And that is the normal factors that we look at, including control, integration into the business. Are they wearing a uniform? Do they have a business card with your name on it? Are they your CFO? Is there economic dependency in the relationship, and the bargaining power that is in that relationship as well? Oftentimes with an employer-employee, there's really not that same degree. So here's the 5 criteria that I've just talked through. So written agreement, contractor can work for other businesses, and also the contractors, the contractors, the principal's competitors. No requirement to exceed hours or free to subcontract, can't be terminated, and has the other requirement, genuine opportunity to seek advice before signing. And that is in the legislation. So if this comes into force, what you'll need to do in terms of your contract for services templates, if you have those, is just make sure that your templates do fit these tests and that you have an offer letter that includes the required reference to seek advice, because it is important that that person understands that they're not going to have a comeback if those boxes are ticked. They won't be able to say, oh, where's my KiwiSaver and my holiday pay, and actually I was sick. Those things are ruled out. So yes, review and update your contracts and give your contractors a genuine opportunity to seek advice before they sign. So here's the more controversial part of the legislation, and the bit that I am a little concerned about. And the reason that I'm concerned is in my speaker notes, I had someone helpfully give me the government's explanation as to why they're proposing these changes. And if you dig into the explanation, it's talking around people having a go, and we know that this happens. People do have a go and bring claims to extract a settlement from their employers from time to time. And sometimes the situation isn't fair, particularly if the employer's made a small slip up, but overall the process has been fair. However, the remedies that government is referring to, and to say this is getting out of control and people are getting, they're saying that the remedies tripled over a number of years in terms of hurt and humiliation compensation. As a practitioner working in this space every day for employers and employees, my view is that hurt and humiliation compensation hasn't really moved much. And the government figures we've been given, I'm not sure are quite accurate or fair. So what I did was I had a look at the Employment Relations Authority report on what has been awarded in the last 12 months. And that is against the employment court's remedies also, and there's quite a helpful analysis. So in 2024, the Employment Relations Authority average award was 17,499, whereas the government is saying that average awards are at about 25, which I think is an exaggeration, unless you were to average it with the Employment Court's awards potentially. In 2024, the Employment Court's awards were 42,500. But you can imagine that when matters get to the Employment Court, they can be on the more serious end of circumstances. So it does reflect maybe the Employment Relations Authority is kind of a fairer picture of what people are getting. And the awards in 2025 actually went down. So far, the average award for 2025 is actually 16,705, which is interesting because when I'm talking to clients, I'm generally saying that the awards are sitting kind of between 18 and 25, but probably that's not 100% accurate. They're kind of more sitting at around 16, 17, which in my view isn't particularly high compared to over time, which apparently the awards have tripled. And the Employment Court, those awards have remained the same, so 42,500. Interesting. So the government's proposal is that there are no remedies, so no compensation and no reinstatement if the employee's serious misconduct contributed to their dismissal. So interesting, because if you're dismissing somebody, generally it's because their behaviour fell in a category that constitutes serious misconduct. And when you think about it and you're developing policies, you're going to have a definition of serious misconduct that's probably quite wide. And we do this on purpose so that we can get to the outcome that is the outcome that you want to get to in those circumstances, which is leaving you with an ability to dismiss. So of course, when you've got an employee who is dismissed, there is going to be a serious misconduct element or contribution that caused them to be dismissed in the first place, unless the employer's got it completely wrong. So in those serious misconduct cases, we lose the first and primary remedy of reinstatement, which is something that the Employment Relations Authority is now increasingly aware of and doing. And they lose compensation, so hurt and humiliation compensation, and loss of benefits, and lost wages can be reduced by up to 100%. So government's spin on this is people are having a go, and if they did something bad, they should go and have no remedies. I'm not sure that I 100% agree with that, because I think the world's not black and white. It can be grey, and there can be circumstances, obviously, where situations are deserving. There are circumstances where employers don't get things right. There are circumstances where, I've got one at the moment where somebody was dismissed for summary for serious misconduct, where there's actually zero justification, but those circumstances are unusual. And the legislation says procedural defects won't make a dismissal unjustified unless they caused actual unfairness. I think that's about right, but we already have that provision in the legislation. We've also got the provision that employers that have limited resources aren't held to the same high standard that an employer with significant resources could be. So I worry a little about these proposed changes. Great for those businesses who, you know, they've got a high turnover and that there's a lot of dismissals and movement in staff. Great, a little bit more certainty, and it probably will discourage people from having a go. The one good thing is it actually might impact on our advocates. So those no-win, no-fee advocates will probably find an income stream that certainly changes significantly. So we may see less of them in the market potentially. Right. So our view is that if this comes into force, you do want to look at what your policies and what your employment agreements say around serious misconduct. And you want to make that definition as wide as possible so that that captures all of those possible scenarios. And there's always, and any other behaviour that undermines trust and confidence, we always like to have an extra bit at the end. And given that the focus will be on the employee and their contributory conduct, it's really important for the employer to keep good records of managing conduct issues or disciplinary processes, because that may well be quite helpful in defending a claim and actually reducing remedies to zero. Interesting stuff. We will wait and see. The next, I think, most controversial change, and it's something that we've seen in overseas jurisdictions but haven't had in New Zealand. I practiced employment law in Sydney in the early 2000s, and they had the high income threshold then. It's an interesting thing, though. So New Zealand's finally caught on. That looking at, so this isn't in law, high income threshold. So at earners of 180K plus, and that is considered to be salary or wages. So it'll be an interesting thing around packaging, etc., to be in or out. But that's the line in the sand that government has chosen, and it is comparable to the Australian comparator. And it is indexed, so it will go up annually. So employees who earn 180K plus won't be able to bring unjustified dismissal claims unless in their employment negotiations they opt in to also being covered by the usual PG protections. Other claims, so disadvantage, discrimination, harassment, those human rights claims, privacy, and all of those other things remain unaffected. But their potential, I mean, when you look at it, you can say tomorrow things aren't working and terminate employment without the required process, without the required justification, simply because of what the person is earning. So I do think that this will have a significant impact. And the reason I say that is that having worked in a jurisdiction that has this, in Australia, they have many established alternative claim rights, including in a more civil jurisdiction for senior executives. So it's not the end of the world that they have the high income threshold. However, in New Zealand, this legislation is purporting to remove all rights in terms of the dismissal itself. So my personal view is just because you're high earning does not mean that your employer should be less fair with you. I do understand that, for example, in a CEO relationship, if the CEO, for example, falls out with the board, there are good and genuine reasons to want to be able to remove that CEO without having to follow a process. But in my experience, those situations are often able to be negotiated and dealt with without the need for this. So what it will mean is employers will have greater flexibility when they're exiting senior employees. 180K plus cash, you can terminate without having to follow your usual process and justification. However, once senior executives become more informed in relation to this change, in our view, they are going to want to be negotiating around that. So the options in terms of negotiations will be either one, they ask that they opt back into the usual protections, which just means that you have to treat them just like all of the rest of your employees, be fair, follow process, have good reason, and they can bring a personal grievance if they're dissatisfied, and it follows the usual process. The other options are that the senior exec will want to negotiate other terms that give them more protections if they are terminated without cause or reason. So, for example, you'll get executives who want longer notice periods, so 6 or 12 months. They may want payment on termination, so a trigger payment if an employer dismisses them, that they have to pay on exit, in terms around how that termination can be effected, so that there are some ground rules. There will be a one-year transitional period for this legislation to be put in place. So if you're an existing senior executive and you've got that 12-month period on your normal employment terms to negotiate something new, or alternatively to negotiate back into the legislation. But if you get to the end of that 12 months and you haven't negotiated a change, those rights fall off. Also, if you change employment during that 12-month transitional period, you no longer have the protection that the changes are implemented immediately. If you are restructured within the same business, you keep the same rights within that 12-month period. So it's not straightforward. And there will be employers that aren't informed and that don't engage with their senior executives. And there may well be claims around breach of good faith by executives who find that they get to the end of implementation, they didn't know about it, and they're dismissed without reason. And of course, you'd be shocked. There may well be some other claims that come out of that. But also, I think in all of these situations, when you lose a remedy, there'll be more emphasis put on other remedies. And as we've seen more recently, the Human Rights Review Tribunal awards are getting higher. And they, I would say, aside from the fact that they take a long time to get there, can be better than what are awarded in the ERA. So you'll find senior executives, all of a sudden there may be a rise in sexual harassment, discrimination and other claims that provide alternative remedies, and a focus on disadvantage, including failure to provide a safe working environment, which is increasingly being used in employment cases. So super interesting area. Happy to talk to you all around that one, because I think it's going to be a real change, and I think there's going to be a lot of discussion at the senior state, and there'll also be a lot of executives wanting to repackage. So you'll find all of a sudden they're interested in superannuation, interested in bonuses and incentives that aren't cash, and other benefits, so that they can get their cash pay down to fit below the 180. Right, so then we've got the political tennis ball, which is the 30-day rule. The 30-day rule would come out, so there's no requirement for your people covered by the coverage provision of a collective to be covered by the collective for their first 30 days. So unions aren't going to like it. Employers will probably be pretty happy, because it removes that whole difficult discussions at the very start when you're hiring people. You're not going to have to, advise people that they're covered by the collective. You'll still have to tell them that there is a union and they can join, but you're not going to get that scenario where people are like, oh, wow, I didn't realize I was getting these additional benefits for being in the union. So yes, so if you have a collective workforce You'll need to, if this change is implemented, update your onboarding processes. It will simplify them for you. And look, there is some discussion around whether unions will try to push to have some kind of similar provision inserted in their collective agreements to give their members greater rights. The government's explanation as to why they're doing this in part is around trial periods, and that most unions do not allow trial periods to be included in their collective terms. And therefore, many new employees covered by the coverage provision are not subject to trial periods. And so by the government doing this, the employer has the ability to impose the trial period without having to impose the collective terms. And obviously with a collective agreement where you don't have a trial period, you can't then impose a trial period on top. So this is something that's been a bugbear for many employers. We've got clients who are dealing with this particular issue, and it's a difficult one. So it removes that whole complexity. Then we've got other changes that have already been implemented. So we've got the pay transparency law, which is interesting. So that came into force in August, and it gives employees the right to talk about their pay. And employers can't take action against them if they do. And if they are treated unfairly, like being disciplined for talking about their pay, they can raise a personal grievance. So it's a new personal grievance grounds. So look, from time to time, we see employment agreements that have provisions that say you can't talk about your pay. Now that this law has come into force, that provision no longer has effect. So if you are reviewing and updating your employment agreements, we would advise you to take that out. And if you are disciplining someone for talking about their pay, we would suggest you stop and seek advice. Parental Leave and Employment Protection Act has been amended. The amendments are kind of a mixed bag of things, trying to fix up some mistakes in the legislation or just scenarios that hadn't been contemplated when the legislation was made. So just clarifying the eligibility where there's non-traditional work patterns or caregiving roles, ensure absences, including around unpaid leave, still count towards work for the threshold. Preterm baby payments don't reduce the 26-week payments, expanding eligibility to non-birth primary caregivers, so adopted and whāngai and surrogacy carers who stop working, clarify the start date for preterm birth, and then increase the maximum weekly parental leave payment amount too, which I'm sure many employees will be happy with. So it's interesting in that some of those scenarios that weren't contemplated are now, there's a bit more clarity around that. And it may be that you should be reviewing your parental leave policies just to make sure that it complies with all of those new changes, and that you're ensuring that those people who now have coverage, or it's clear around, are in fact covered by your policy. So if you need help with that, let us know. And then we've got some further changes. Crimes Theft by Employer Amendment Act. So that came in already. And I think this is super interesting. So if an employer deliberately withholds an employee's pay or entitlements, so that could be their contractual entitlements and or their statutory entitlements, and the employer is doing that knowingly and deliberately, so there needs to be a degree of intention there. So it's not a mistake or poor calculation, it is actually with intent. That actually, the act in withholding that pay, it becomes a criminal offence. So I've talked about this before. I don't think the police are manning calls from employees who are upset that they haven't been paid, but it is a super interesting change, and it does recognise the real seriousness for employees of having their pay withheld. Obviously, it's been designed for those employers that are deliberately deliberately mistreating their workers. It's not the general employer base that we deal with, but where we've got vulnerable workers whose employers are withholding their pay, this gives another enforcement right, and it gives criminal sanctions, so potentially imprisonment, fines, which is quite serious. So we've already used this legislation in our business where we've got employees who have been mistreated and deliberate withholding of funds has occurred. It is just another avenue for claim and leverage to get employers that are willingly not paying to ensure that they comply. So again, an interesting right. Then we've got the controversial pay equity changes that were passed under urgency over the course of 3 days, with consultation occurring between government ministers but nobody else. It's quite unheard of, and to do such a change from a legal perspective, and it has removed 33 pay equity claims. It has effectively ended. So it has had a huge impact. It has made the test harder, the threshold of proof and stricter criteria. So it's back to the drawing board. It doesn't mean that there can't be claims. It's just made the claims harder, and those claims that no longer are able to be pursued will have to be relooked at. So super interesting times that we're getting that type of change without any form of consultation. We've got the partial strikes change, which allows an employer to make a pay deduction where there's a partial strike. So when I say partial strike, I mean, for example, a slowdown. So the employee is still at work, but not performing at capacity. It's a method used by unions and allows the employer to deduct a proportionate amount as a result of those types of actions. So just giving employers with a unionised workforce another means of getting people back to work and dealing with their unions. And then we've got some other changes that we're looking at. We've got the Holidays Act reform. How many years have we been waiting for this? I think maybe 9 at least. We've been talking about this. We've gone through successive governments. No one's been able to figure out how to do it best. It's almost in the too hard basket. We've got MB who can't get it right with their own staff. So what hope do we have with the current legislation? So what we do know is that the current legislation will likely be scrapped. It'll be moving towards a one-size-fits-all, very simple model to accrue leave entitlements. But what we had and that went out for consultation simply wasn't good enough. That was the feedback. And so we're back to the starting blocks again. So watch this space. And there are also some changes proposed to the Human Rights Act. There's a private members bill extending prohibited grounds around gender identity and variations of sex characteristics. That's an ever-evolving area, and again, watch this space. We've got some cases that have come through that are interesting. I know I haven't got a lot of time left to talk to you about it. We've got Huntland, Hampshire holiday parks. This case is interesting for a number of reasons, but one of them is around availability. So motor camp managers, they were employees, they resigned and were renegotiating an arrangement. They raised personal grievance, and in the negotiation, in the grievance process, they claimed unjustified disadvantage because their employment agreement didn't include an availability provision. And the reality was they were on call. So for a motel park manager, of course, if a situation arises, an emergency, they were required to attend call out, and they said they hadn't been paid for those on-call hours. So all of you who work in the space around availability will know you have to have an availability provision, you have to have guaranteed minimum hours, and you have to have some kind of payment for being on call, which they didn't have. Probably the employer naively thought they were, I think they were salaried, that covered it off, reasonable additional hours, etc. And what the court said was that there was the requirement, the Employment Relations Authority said there was compensation required for their availability, and the intention of the parties around availability is relevant if there's no provision in the agreement expressly saying we need you to be available. The reality was they needed to be, and so they were entitled to bring a disadvantage claim in relation to the failure to be compensated for availability. We've got another one, which is a contractor and employee place. I would have thought it was pretty obvious. It was an accountant who ran their own consultancy business, but were engaged as a contractor CEO. That type of arrangement is potentially dangerous, and this became dangerous because it slipped into after a certain period where they were paying him a very high hourly rate to perform really what an employee should be doing. They negotiated for him to do longer hours, lower pay, more in the office. And then there was a dispute about whether and when he became an employee. And of course, it was determined that he became an employee from the time he became working full time. There was a break from the type of consulting arrangement at that expensive hourly rate. He was under greater control. His hours of work increased. He was expected to be available outside of hours. He couldn't delegate, which a contractor should be able to do. He was really integrated in the business and not in business in his own account by then. So he wasn't able to do other things for other businesses. So I would have thought it was an obvious result. And then we've got Cummings and Cam Transport. I like this case. This is an interesting one. And it just reminds us the importance of keeping important private matters private. So we had a truck driver. He was a very experienced truck driver. He held himself up as having a high reputation. He refused a drug test, which obviously that causes suspicion. But he was doing some really long drives, and his reputation was important to him. The fact that he refused the drug test was communicated by a manager to his peer. And that in itself caused gossip within the business that he was on drugs or that he was trafficking drugs, and he was driving long haul. And he said, well, that caused huge distress to him, that people were speculating he was a drug user or a drug trafficker and he couldn't be trusted. He did, in fact, have another drug test and cleared. He told the employer about it and said, I'm really upset. I need you to investigate this. This is super important to me. They didn't properly deal with it. He felt ignored. He resigned. And it was found that the employer did breach his privacy. That information around refusal of a drug test should never have been shared below manager level. And his peer, having heard that and then shared it within the business, caused him humiliation, loss of dignity, injury to feeling, and he was awarded $30,000 for that in damages. He didn't actually get lost earnings compensation, which is interesting, but that's a whole nother conversation. But the $30,000 award really goes to show that the HRT is maybe a better forum for better remedies as well. And interesting, you can obviously pursue more than one type of claim, and privacy could sit alongside a personal grievance, unjustified dismissal. We've also got this Medi-Spa case. I won't go into a huge amount of detail, but a worker became pregnant, was sick, morning sickness, and was effectively forced out of work by the employer, put on parental leave when really she was way too early in the pregnancy, and she didn't qualify for any type of government payment, and effectively it led to her resigning. And there were awards against the employer and under the HRT, jointly and severally against the employer and its directors. So look, I don't think many employers would make this mistake. It was a small business though, and probably they didn't have good advice. But yes, she was awarded $99,000 for the employer's action. But I think the newspaper articles that were talking about it showed her with her 7-year-old son, which is how long it took her to get a decision in the HRT. So that's pretty terrible that she was pregnant and it took 7 years to get there. So there's where we're at. Health and safety reform, consultation, changes expected, don't know what they are. Lots of stuff around small business, focus on serious risk, move away from psychosocial risk. All the stuff that we've been talking about mental harm, it's still there, it exists, and we've now got parallel jurisdiction in the employment space where it's become a disadvantage claim. We've got the Cronin Lamp case, which is precedent setting, over $1 million in awards for these two people. And we've got government now moving WorkSafe to focus on ladders and trip and fall and other injuries, and saying to small businesses, hey, we're going to make it easier for you. But I think it just is going to create an odd scenario where we've got our health and safety potentially focused more on the big or the most risky activities, and we've got the employment space that's looking at mental harm, psychosocial risk, etc. So let's wait and see. We're certainly taking a step back. We're not following Australia. Maritime New Zealand and Gibson, this is the Port of Auckland CEO. An employee was killed in a crane accident, and he was found to have failed to meet his duties under the Health and Safety at Work Act. So it was a prosecution against a CE. Scary stuff. Means our CEOs need to have a good understanding of their business and the risks, and he was found not to have met those obligations. Right. That is a whistle-stop tour of the employment law changes. I appreciate I've rushed through them. As I said, I'm more than happy to talk or answer questions at the end. This is really interesting stuff. Shush, I'll move along to you.
Cool, thanks, Christy. Today I'll cover off at a high level incoming and current immigration changes that are relevant to workplace law. This first slide is on what we call the FYSI bill. This bill is before the Education and Workforce Select Committee and is not in effect yet, but is likely to come into effect. And in essence, I think there are three relevant pieces here. Firstly, the bill gives the government the ability to expand levy charges to employers hiring migrant workers and also education providers where migrant students study. The relevance of this change is that the government could use the change to charge employers a levy of e.g. $1,000 to $2,000 per year for each migrant worker that they employ. So this comes off the back of something that's used in Australia, which New Zealand's immigration system follows, especially for our accredited employer work visa. So in Australia, there's a levy where certain employers must pay when sponsoring foreign workers for certain types of visas. So for example, an Australian business with an annual turnover of more than 10 million per year that wishes to, in essence, employ a migrant worker for a period of 4 years would be liable to pay a levy of around $7,200 when they're sponsoring the worker. So it's possible that New Zealand might move to an approach that is similar to this Australian approach if the levy or where the levy charges are sort of incurred onto the employer, and employers might want to look at planning around these increased costs, including whether, for example, if there are any campaigns to employ migrant workers for hard to fill roles to potentially move these forward. This is probably going to be something that comes around next year, so there will still be some time. Secondly, the second sort of relevant workplace law change will be around the expansion of what's captured or who's captured as part of migrant exploitation offendings. So the expansion captures employment-related person as a to include agents and people involved in recruitment of people who, in essence, become victims of migrant exploitation. Now, I guess the takeaway for this change, when it does come in, and if it does come in, is that if you're recruiting for roles that are filled by migrant workers, my recommendation here is to be vigilant for migrant exploitation, as there is a risk of potential criminal offending if the worker then becomes a victim of migrant exploitation. The maximum penalty for this offending is 7 years in prison and a fine not exceeding $100,000, which also extends to the person completing recruitment tasks. The third change that is semi-relevant to the workplace law is a change around liability for deportation. So currently, the current position is that if a migrant worker pleads guilty and then obtains a discharge without conviction, they generally don't have deportation liability raised. Now, after this change comes into effect, and if it does come into effect, what the change will mean is that even if the migrant worker gets a discharge without conviction for their offending, they'll still have deportation liability raised against them. So if you work, for example, in the HR space and capability space, you might get inquiries for support from migrant workers who have resident visas but have convictions that trigger deportation liability, because even if they have a discharge without conviction, they'll need to deal with this deportation liability, and they might need a letter, for example, from you as employer to support any submissions against their deportation liability. Cool. Moving along, next slide. Here, there has been a number of cases recently which stress requirements to consult migrant workers as part of good faith obligations. So I've got a slide here on this as a reminder, especially because a lot of migrant workers will have visas that are due to expire this year or in the next 24 months. This is just a reminder that visa support should not be withheld by employers. There is a requirement to continuously consult without delay with migrant workers on changes that may impact their ability to apply for a visa. That could be a work visa or a residence visa, and that employers should explore alternative options, including in relation to visa support with migrant workers. I'll just move on to the next slide now. This next slide is a further reminder of the offences under the Worker Protection, Migrant and Other Employers Act. The total number of fines issued under this act has jumped quite largely. So for the 2023 to 2024 year, only around $63,000 in fines were raised, and this has jumped to $395,000 for the sort of most recent 2024 to 2025 year. So we anticipate that immigration will continue to issue fines at this level or at increased levels. So this is just a reminder, in essence, to make sure that if you're employing migrant workers, to make sure that you're employing them in a manner that's consistent with the conditions on their visas, and you're also complying with requirements to supply documents to Immigration New Zealand within 10 working days when required. And also that the bigger one there is if you're employing anyone that is a migrant worker, it's also important to check that they have the ability to work in New Zealand, and it's not, for example, the case that you don't have any evidence of this, because there is also an offending whereby it's triggered where if the person doesn't hold a visa, then there is a potential of being charged, for example, $3,000 under this act for employing someone who doesn't have a visa. Moving along, next slide, please. Over these next two slides, I've got high-level changes in regards to immigration policy summarized. The first one is a change in regards to the skilled residence median rate, which has increased to $33.56 per hour. So the relevance here is if you have any migrant workers that are looking to apply for residence, they'll need to be paid when they apply for residence, so at the time the application is submitted, this rate or a higher index rate if they're, for example, relying on being paid twice the median rate. So if I guess just one thing to note here is you don't need to pay these migrant workers that are applying for residence the increased rate right now. You only need to pay them this rate when they apply for residence. Next on this slide, I've got, if we can move back, to this slide. So the government had announced increased part-time hours for student visa holders. Now, what the practical sort of implication of this change means is that starting from the 3rd of November, new student visa applicants and visa holders will be approved, in essence, part-time work hours, allowing for 25 hours per week. Now, the practical thing to just take care of here is that student visa holders currently can still only work 20 hours per week, and this change isn't automatic. So, for example, if you have a student visa holder that's working part-time for you at 20 hours per week, and then November ticks over, that student will then need to submit a variation of condition application to get to be able to work that extra 5 hours per week during semester. It's not an automatic change. Last on this slide is just comments around the job check redesign. There'll be additional or there'll be a change in questions that's required from the form, including why a role is needed, the size of the business, and how many New Zealand citizens and resident visas are employed. So this is just a change to the job check application form. Next slide, please. On this slide, I've just covered off in essence, a change to how immigration will look at roles. So currently, the current approach is to use ANSCO, which is a shared approach across Australia and New Zealand. The change in terms of moving ANSCO to a New Zealand national occupation list was announced last year, but the change hasn't come into effect yet in terms of a full change. What the government has announced is a partial sort of change, whereby the roles here on this slide, if workers are working in these roles and their 3-year maximum period of stay ticks over before November this year, these workers will be able to benefit, in essence, from a skill level change from holding, in essence, or from working in roles that are technically now still skill level 4 to 5, but will be treated as 1 to 3 in the future. So these workers will then be able to extend their work visas or / their accredited employer work visas for a full 2 years if they're working in any of these roles, and their maximum period of stay expires before November this year. Moving on to the next slide. The last high-level change is in regards to new seasonal, in essence, 2 new seasonal work visa categories that the government have introduced. So these are called the new Global Workforce Seasonal Visa and Peak Seasonal Visa. I've got information here on both of these visa categories, along with the roles, visa, so the validity periods and requirements. I won't talk to that deeply. Feel free to have a look at the slides. I think that will bring my session to an end, and then we'll move on to Tash.
Hi, everybody. Thank you so much, Shush, and thanks to the AMM team for inviting us at Pillar to speak at today's webinar. It's awesome to have that opportunity to be able to connect with you all. So just a little bit of a refresh in who I am and what I do. So my name is Tash. I'm a managing consultant at Pillar Consulting, and I do both health and safety and HR consulting. So the AMM team have invited us to come in today and have a chat to you about what the changes are to the drug and alcohol framework. There's a change in listing. So this is just a little bit of a list of what I'm going to cover. In the interest of time, there are a few things that I will whiz through, but I want to start just by talking about what that the change to the standard actually is, so we can all understand that. The rest of what I want to chat about as well is just sort of the changes to some of the urine testing and sorry, just other bits and pieces that have been quite topical. So, yeah, sorry, Christy, we'll jump to the next slide and I will jump in and start having a chat about it. So just that next slide, Christy, sorry, that understanding the regulatory. So you heard me mention the standard of, what we detect when we're looking at the different, sorry, Christy, we was whizzing through a bit quick, are we? Just back to that one with the understanding the regulatory changes would be amazing. Thank you. No, it's all right. I can see them flicking through. We're all good. We're all good. Okay, so what this new standard is saying is we're lowering the detection thresholds for a couple of the different drugs that it's detecting. So cocaine, we're going to be looking at lower thresholds, and the benzodiazepines as well. The drug panels are expanding now to include more prescription medication, so things like tramadol, fentanyl, and oxycodone. The THC limits will remain unchanged, so those will stay the same. So this standard was introduced back in 2020 period, and having a chat to the team at the Drug Detection Agency, TDDA, they plan to have these new changes implemented by the end of this year, but at the moment both standards do apply, the 2008 and the 2023 standard, until the end of 2026. So just next slide there, Christy, thank you. So just a little bit more about the detection limits themselves. And this slide looks like a whole load of sciencey numbers. I'll do my best to explain this for you. When we're talking about cocaine, the current level is that 300. It's going to be dropped to 150. So what that means is those initial screening tests are going to be able to detect lower levels of cocaine in the urine. What happens when they go off to the lab, the confirmatory result, that threshold will also drop from 150 to 100. So again, it's picking up on those lower levels. Benzodiazepines, so these, for those who don't know what this sort of means, those are those prescription medications, often sort of, depressants and antidepressants, things like that, medication used to treat some, anxiety medication, seizures, things like that. So that's what a benzodiazepine is, and that one they're actually going to lower the detection levels as well. So they're going to be able to pick up on lower levels of those in your urine screening tests. Next slide, please, Christy. Thank you. So another thing they're doing is they're actually expanding what we can report on. Now, again, a little bit sciencey. I'll do my best to explain what this means. But if you have, for example, an amphetamine that is detected, traditionally that would be the only one if it was the only one that was above the detection level, it's the only one that they would be able to report on. But now if there's other drugs in that family or that parent metabolite family, they're going to be that are below the limit, they can report on those as well. So it gives a wider picture or fuller picture of drug use. So if someone returns a non-negative result for amphetamine, when they go back for that confirmatory testing with the lab, if there are traces of methamphetamine there as well, that report will show that. So as I say, that's great to understand a little bit more wider picture of use. The next slide, please, Christy. So this is not actually a part of the changes to the standard, but this is something that you would have all maybe heard. There's an introduction to oral fluid testing that's happened within the last couple of years, and conversations we're having with our clients around understanding a little bit what's the difference between the two and when would you use them, what would be appropriate. So the urine testing, it detects past use. So it's looking at a bit of a picture in terms of what a person might use within a week period before. So fluid is going to pick it up, what they've used within hours. So it's a little bit more, may have used today, for example. So just a little bit of information here. And again, you'll see it in the slides when they send out, but urine testing is great for your pre-employment, your random testing when you want to understand habitual use. Whereas if someone's had an incident or you've seen some reasonable cause indicators with someone showing up for work and you're concerned they're at risk of impairment, that oral fluid might be a better choice for that. Next slide, please, Christy. Thank you. So look, what do these changes mean for your business? So I think, probably the biggest thing here, it's a really good opportunity for us to ask, should we make changes to our policy? Yes, for sure. If there's things there that you feel, it's a great opportunity to chat to the team at AMM Law and ask them if they think that change to your policy is appropriate. But if you don't, whenever we see these changes, it might be just a really good opportunity for you to think, what is our risk exposure here? We don't have a policy in place, should we? A policy can help, like I say, define how testing occurs, when it's needed, what substances are tested for, and what happens if someone does return a non-negative result. If you can just flip through to that next slide, please, Christy, that risk management slide. So what we're wanting to do here, when you're sort of deciding whether you should have something in place, it's asking that question, considering the nature of your work. If someone did have a lapse in concentration or was at risk of impairment due to use of drugs in their system, would that pose a risk? So if you've got people who are operating machinery, handling hazardous substances, working at height, absolutely. And make sure that people were as safe as possible to be able to do that work safely. The next slide, I've included this topic because it is a question that does come up quite often. If something's prescribed to you, so medicinal cannabis, this is the same for some of those that are benzodiazepine medications. If something's prescribed, people are sort of saying, are they okay? Can they still work? That impairment still exists, or that risk of impairment still exists. And there's not actually a testing framework around understanding whether or not someone is impaired. It's just telling you whether or not that is present in their system. And medicinal cannabis, regardless of whether or not it's been prescribed, it still is, you're at that risk of impairment. So that next slide, my last slide there, Christy, is just talking about, you know, where you want to have a conversation, again, if you are concerned about prescription drugs, still really important to have that conversation around, are we in a safety sensitive role? You know, lab tests can't distinguish. So review your policies, make sure that language uses that risk of impairment, not just substance detection. And also consider including things like fitness for duty assessments, asking your people or making them aware that if you are taking any prescription medication or anything that you know, has that risk of impairment, we want to know about that so we can make the right decisions for you to keep you safe. So I think I do have one more slide there, just around workplace culture. So looking at the time, I'll just wrap this up quickly. But this is a really good sort of topical conversation or things to consider around, you know, there's a lot of movement towards wanting to create positive wellbeing cultures in workplaces. So it's a really good conversation starter around what is the intent behind our policy. You know, we could use it as, you know, obviously we do have a legal duty to consider our risk, but can we use it as a tool to actually protect and support, to identify people who might need help and enter some of those conversations around rehabilitation? Not appropriate in every situation. I think it is important to consider that on a case-by-case basis and relative to the risk and the environment that you're working in, but it is a really interesting point to consider. That's all from me. Thank you very much. Yeah, back over to you, Christy.
Look, when Tasha and I were briefing around her slides, certainly we are encountering a lot more inquiries from our clients, particularly in industries like transportation, where we've got drivers who are susceptible to lapses in concentration, etc., safety sensitive type work, and medicinal cannabis. And it is certainly a conversation that needs to be had, because if someone's prescribed medicinal cannabis, particularly with the THC content above the limits, they can be both impacted but also allowed to be taking it. And the missing point there is around, are you getting advice from your prescriber or an appropriate occupational physician around what impact that might have in terms of your ability to work? And it may be, as with other medications, that there needs to be some advice given around when you're taking it versus when you're working, particularly when there's shift patterns or work isn't always following a standard pattern. So definitely things to think about. Now, I know we've just passed the end time, but I do have some questions which I'll go through quickly on my part of the presentation. So the question I had was, for the contractor test, do you need to tick all of the boxes to be considered a contractor? That was the 5 boxes. Yes. You need to tick all of the boxes, and if you tick 4 and not the last, for example, you don't encourage them to get advice, then you'll go into the usual test of employee. So we'll be looking at the true nature of the relationship. The next question, are you saying the 180K threshold is a done deal or it's still under review? No, it's not a done deal. It is before a select committee, and therefore it is not guaranteed. So it is a watch this space. And the last question, which is a really good one, thank you. If you're under a 90-day clause, so you're in a trial period, are you able to take a PG for being dismissed because you spoke about your pay? Like it. The grievance is a new grievance. So in a valid trial period, you can't bring an unjustified dismissal claim, but you can bring a disadvantage or other claims. So and I haven't researched this, but my take on it would be adverse treatment due to speaking about remuneration is a valid grievance. And I don't think that just because you've got a 90-day trial, that would be a valid ground to dismiss. So I think you would have a PG, just like the other PGs that are preserved during the trial period. And then Taj, a question for you. What is the rationale behind the lower drug screening levels? Are there any cases or research that's come out recently, I assume, that would justify that?
Yeah, really good question. I actually, that's one that I might come back to you on, if that's all right. I was just, you know, like I say, we've been made aware of these changes. When I was chatting to them at the Drug Detection Agency about them, it was more, there was a lot of conversation more around what that means or what that may mean in terms of changing policy language. But I'm not aware, actually that's something, Christy, you might be able to help me look into, if there is any sort of precedent or legal framework that's sort of in behind why they've made these changes. So we can certainly come back to you on that if that would be all right.
Thank you. And the last comment was with benzos, the comment is it not almost a breach of privacy if you're having to disclose that around your mental health? And this is always a complex issue, right? It's the same for prescribed CBD. Same thing. Yes, it's that fine balance, isn't it, Tash?
It is, absolutely. And Christy, this is something you and I were talking about when we sort of ran through this together at the end of last week. Look, it's got to come down that at the end of the day, we're looking at the risk. We want our people to show up and be healthy and safe in the work that they are completing. So if the medication that they're taking does have the ability to affect that, them to be able to do their work safely, it is reasonable to ask that question around whether there is something that they are taking that may have that, put it at risk of impairment. And anything you want to add to that, Christy? I mean, I think it really does come down to that risk, doesn't it?
So obviously we've got the human rights considerations around not discriminating against someone because they've got a mental health disorder. My experience in dealing with clients around this, and I've had a number of similar kind of issues around prescriptions for mental health, is generally employers do want to be understanding and they want their employees to be mentally well. So the fact that you're on benzodiazepine or other drugs for mental health reasons certainly shouldn't be a rationale for an employer to take adverse action against you, but it is a genuine conversation if that medication has the potential to impact your ability to focus, might put you at risk. If you're driving a very heavy vehicle, for example, and you're taking medication that might impact or make you drowsy, that's a genuine and reasonable concern. So it should be good faith engagement. I've got clients that will commission a report. For example, a psychiatrist might be able to talk around the medication, how the medication should be administered to ensure that the employee is safe while also being able to manage their mental health. So it shouldn't be you can't just because you have a safety sensitive role. It's just that the mental health, the risks around that also need to be managed. So that would be my view on that. Yeah. So look, I want to say thank you so much to everyone for coming along. This is the first webinar we've done in the new entity, and we plan to do many more of these and to bring experts in from time to time as well. We will be offering some training shortly around director obligations, and we'll certainly be expanding and sending more newsletters and the like. Lovely to have you all here. Reach out if you've got any questions, more than happy to engage. And thank you so much for your support. Have a lovely day. Thanks, everyone.